Hello, everybody. Here are questions you should never ask at a pretrial deposition. You want to know what this is and why it's so important to understand? Come join me for a few moments as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you should know what a deposition is, in case you don't know. A deposition is a question and answer session. Now, before I get to that, let me just go back for a second. When you bring a lawsuit, a civil lawsuit, seeking money as a form of compensation, what you are doing is you're basically trying to get the people you are suing basically to recognize, hey, you guys are responsible for my injuries. Now, when you bring a lawsuit, your goal is to show, number one, that there was wrongdoing, number two, that the wrongdoing was a cause of your injury, and number three, that your injuries are significant or permanent. So now, once you bring a lawsuit, let's say it's a medical malpractice case, you decided that your doctor was careless and caused you significant harm and injury, right? Now you decide to sue your doctor. But wait a second. You can't just start a lawsuit in here in New York the same way you do for a car accident case. Instead, we have to have a qualified medical expert obtain all of your medical records and then have a medical expert review all of your records. Only if our medical expert confirms, number one, that there was carelessness, number two, that carelessness was a cause of your injury, and number three, that your injuries are significant or permanent, only then are we permitted by law to go ahead and start a lawsuit on your behalf. So now, here's the question. What is a deposition? Well, during the course of your lawsuit, there's a process known as discovery. Discovery is nothing more than learning information from each side. We have an obligation to provide documents and medical records to the defense, the attorneys who represent the people whom you have sued. Likewise, the defense attorneys have an obligation. Hey, Michael, nice to see you. Likewise, the defense attorneys have an obligation to provide us with medical records of their own clients. It might be of a doctor. It might be of hospital records. So that's known as the discovery process. In addition to the exchanging of documents, we are also have the opportunity to go ahead and question the people whom you have sued. Now, typically what will happen is the defense attorneys will have an opportunity to question you, the injured patient, first. Again, that's known legally as a deposition. And really, that's nothing more than a question and answer session given under oath in your lawyer's office. Now, you should know something, and not many people share this with you. This question and answer session is known as pretrial testimony. And guess what? There's no judge there. There's no jury there. This takes place in your lawyer's conference room. The only people who are there it's plural, are your attorney, you, the defense lawyers, however many there are, and a court reporter. Now you might be asking, why a court reporter? Well, a court reporter is there to record all of the questions that you are asked and all of the answers that you are giving. And all that information gets put and transcribed into a booklet called a transcript. And by the way, you should know that transcript can and will be used against you when you go to trial a couple of years down the road. So now, let me take a water break, and I'm going to continue and explain why this is so important. All right. Michael, how are you? I need to be on News 12? Yeah, excellent. If you have a contact there, let them know or put me in touch with them. I'll be happy to get on there. Thank you. I appreciate that. Okay, so now, after the defense attorneys have had an opportunity to question you, the injured patient, now a few months down the road, guess what? We have an opportunity to question the doctors and the hospital staff whom you have sued. So now, here's what's very interesting. Some people believe that, hey, there are certain questions that cannot be asked during this question and answer session. Well, I'm going to share something with you. The title of this video is a misnomer. It's a bit deceiving. Hey, Michael, yes, definitely. Let's talk another time. That would be great. Let's catch up. So the title of this video is really a misnomer. Now, why do I say that? I say that because in law, in these civil lawsuits where you're seeking money as a form of compensation, you know something? There are no questions to which we cannot ask. Let me put that another way. Every question we ask has to be answered, except for two types of questions. And I'm going to get to that in just a moment to explain what they are. But the reality is that I have an opportunity to question the doctor whom you have sued, and the doctor has to answer every single question that I ask. Now, there are different ways to ask questions, and I might ask a question that is not very artfully phrased. I may ask a question that is improper. And the defense lawyer has an absolute right to say, hey, Mr. Oginski, that question is not phrased properly. Please rephrase it. And you know what I'll do? I will rephrase it. I can rephrase a question 5, 10, 15, 20 different ways to try and obtain the answer to my question. That's not a problem. However, I rarely will hear the objection. Objection, you can't ask that question. I direct my client not to answer that question. You want to know why not? Because this is the discovery phase of your lawsuit. And what that really means is we're entitled to obtain lots of information, even though we may not be able to use it at the time of trial. Now, obviously, I can't turn around and ask a question that says, hey, Dr. Jones, how many times do you beat your wife each night? You know why? Because that's so outrageous. That question is so ridiculous, right? And it's got nothing to do with the claims that you're making in this case. In that instance where my question is so ridiculous and so outrageous and so out of this world, the defense attorney has every right to stand up or to yell out, objection! That question is palpably improper. And that would be true. It is palpably improper. And he's entitled to turn around to his client and say, I direct you not to answer that question. That's one exception. Now, what's the other exception? The other exception is if I turn to the doctor and I say, doctor, isn't it true that you met with your attorney before this question and answer session? Now, it is true. Every doctor does it. Every client does that and meets with their attorney. They prepare them for the questions that we're going to ask them. Now, here's something else. When I ask these questions, the doctor pretty much knows exactly what type of questions I'm going to be asking him. Why is that? It's because his lawyer has prepared him for the types of questions that I'm going to be asking. That's known as a prep session. So now, here's the other type of question that the doctor is fully entitled not to answer. Doctor, what did you and your attorney talk about during this preparation session? That's objectionable. Objection, Mr. Oginski, you can't ask that question. I direct my client not to answer that question. And guess what? The defense lawyer would be 100% correct. You know why? That's because conversations between the client and the attorney are confidential. We call that the attorney-client privilege. And anything that the two of them discuss together, outside of the presence of anybody else, I can't learn the contents of what they talked about. So, if I believe that the defense lawyer told the doctor to say certain things, I cannot turn around and say, doctor, what did your attorney tell you to say? That's an objectionable question. And he's fully entitled to tell his client, do not answer that question. But besides those two types of questions, one which is protected by the attorney-client relationship, that's privileged and confidential, and one that is so off-the-wall, outrageous, that's palpably improper, the attorney is fully within his right to tell the doctor not to answer those questions. However, everything else is fair game. Everything. And even though it may not be directly on point, even though it may not directly relate to evidence that I can use at trial, the reality is that I am fully entitled to ask that question, and I'm entitled to get an answer to that question. Now, here's another question that some people think I can't ask. Doctor, based upon the facts that I've described to you, would you agree that failing to do A, B, and C would be a violation from the basic standards of medical care? Yes or no? Now, the attorney objects and says, objection, that's improper, you can't ask that. Well, the reality is I can ask that. That's known as a hypothetical question. And hypothetical questions are critical to getting the doctor to admit that he actually did something wrong if, in fact, the facts as I describe them are true. And later on at trial, if the jury believes our set of facts, now the doctor has said in his own particular words, using his own testimony, that yes, if these facts are true, then it would be a violation from the basic standards of medical care not to do A, B, or C. That's a very powerful tool that we have, and something that every single attorney who handles these types of cases should be asking during this pretrial question and answer session. Because this makes or breaks your case, asking hypothetical questions. These are the key questions that we want to establish, and that if we are successful in doing that, now we've basically proven our case. We've shown that we are more likely right than wrong, that what we are claiming is true. And now maybe we can even ask the judge for a directed verdict before ever getting to trial, asking him to give us a judgment in our favor based upon the doctor's testimony. That's a possibility. So let's get back to the original question I raised in the headline, which is, in fact, a misnomer. Are there any questions that we cannot ask during the pretrial question and answer session known as a deposition? The answer is no, there aren't, except for those two that I mentioned before. You know, I realize you're watching this video because it shows up on your Facebook feed, or if you're watching it on the replay, it's something you're actually searching for, and likely you have questions about what happened to you. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me, and I'm going to put the number up on the screen. Here we go, 516-487-8207. And let's put it up there. Very good. Or you can reach me by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a fantastic day. Bye, everybody.